All right, everybody. Thanks for coming. Welcome to class.
Hey, Eddie.
Ian and Ruby, glad to see you're here.
Yeah, me too.
Your meeting is Monday, right?
I'm not sure. They supposed to get back with me on the response because I'm gonna have to preview what the response that the lawyer's giving to the summary judgment. I was just doing the affidavit, but that should be happening before Friday or tomorrow, I should say. We'll see what happens.
Helen, has there been any further update or movement on your case?
Monday at 9 a.m.
What's happening Monday?
Well, the judge is supposed to respond to my motions. We'll see how he railroads me.
Via a motions hearing?
We already did the motions here. He said he was going to respond.
Huh.
Yeah, well, I want that response in writing.
Well, don't say it that way.
I moved the court to provide a response in writing with all the effects of law that you used to make this judgment.
It's real easy just to go, the defense would ask the court to please provide the defense with a written copy of that ruling, please.
Yeah, I can do that too. But that doesn't mean he'll do what he's supposed to.
No, it doesn't. But neither will it get you what you want by going the other way either.
Ask and you shall or shall not receive.
That's true. But when he's reading the order and you ask him for a copy of it, then that shouldn't be a big issue and it shouldn't be a big ask, right?
Nope. That gives me time to respond.
It's hard to be sometimes polite or just pleasant, but yeah, it's better to be pleasant as much as you can and kill them.
Pleasant but firm. Yeah, it's a trial.
It is, isn't it?
You're damn right. For us women to be pleasant but firm, that's a feat in of itself.
Yeah, these courts, they just know how to really put your patience to the test, that's for sure.
The goal is to convict and railroad as far down the track as they can to where you can't move.
Well, that's true, and it's to wear you out to the point where you give up. You don't. If you got people like us that are persistent, that ain't gonna happen, is it?
Nope. I'm too far into the game now to give up.
Well, good.
Okay. So, what is the primary rule of going to court, everyone?
To get justice.
To be heard.
Yeah, there you go. To get justice and be heard.
No. What is the primary rule for you when you go to court and things start happening? What's the primary rule?
Listen to what you hear and object.
Listen to what you hear. Okay? Why is that the primary rule?
So that way you can object accordingly and timely.
You can react accordingly. Okay? Whether it's objecting or anything else, you can react accordingly. Now, that doesn't mean reacting should be the only thing you do, but when it's not your turn to speak and somebody else is, you need to be paying attention and really hearing what's being said. Okay? You can't just pretend to listen and make it sound like Charlie Brown's parents in the background. You've got to be able to understand what's going on around you when you're in court. Failure to do that means something gets by you. Something gets by you, it can be something that damages you irreparably. So, part of listening to what you hear gives you the opportunity to formulate questions to use in your cross. Wouldn't you agree with that?
Absolutely.
Okay. Now, should you wait to have questions based upon what you hear?
If you don't have to do so, don't wait. Have it ready.
Why would you have to do so?
So that way
when would you ever have to wait to have questions ready?
you don't want to wait to have questions. You want to do so immediately, question and not wait.
Okay, I think you're kind of missing my point here. So let's try this again. We agreed that listening to what you hear can give you an opportunity to add questions to your cross-examination, right? Operative word there being add questions to your cross-examination. So that means you should already have things you plan on asking in your cross-examination, right?
Yes.
And what should those things be based upon?
The facts.
Facts of the case.
The facts relative to what?
The case.
The case.
The case
law.
being what?
Your subject matter jurisdiction, your...
No. The case being what?
Being a complaint.
A complaint that does what?
Creates an offense.
Alleges an offense.
Or alleges an offense, right.
Okay. And what does an offense have that you need to be basing your questions on?
The elements of those facts.
The elements of the offense. That's what your cross-examination goes toward. A combination of the facts as they're being testified to and the elements of the offense as it sits in law. Right?
Yes.
You've got to know if the facts being testified to line up with the elements of the offense, don't you?
Yes.
And you've got to know whether or not the facts being testified to on the stand satisfy all of the required elements of the alleged offense, right?
Absolutely.
Okay. Now, that is always your baseline set of questions. How do you prove that the testimony is or is not true relative to the elements of the case? All right? Doesn't matter who's given the testimony. That's how you have to line it up with the elements of the alleged offense. How many elements of an offense do they have to assert and prove in order to win?
All of them.
All of them. Can't be some of them. Can't be most of them. It is not majority rule. Either they allege and argue and prove all of them at trial, or they lose.
Mm-hmm.
Period.
Yep.
So, the first thing you need to understand is what the charge is, how it breaks down into what individual elements, what those elements mean, what facts are required to prove those elements are either true or false, and exactly how many of them there are and what kind of testimony it would require to get them on the record. Right?
Right.
This is the kind of stuff that has to be running through your brain when you're preparing your cross-examination questions and the structure of those questions. Remember what I told you before. The order of things matters. Right?
Yes. Yes.
Okay, unless y'all got background noise, you can unmute and talk. This is a play-along class, okay? Just if you got a bunch of background noise, then stay muted. So, when I say that listening to what you hear can give you additional questions to ask because they might lead to something important, that's something you want to address. You want to add it into the structure of what you've got, but you don't want to do it in a way that disrupts the structure you have and causes you to lose the flow that lineup is supposed to produce. Okay? So, the first thing I want to do is show you part of a video. I'm not going to show you the whole thing. I'm going to give you the premise of what the video is and why we're looking at it. Let's see. That's the screen. That's the application. All right. Can everybody see the video with the guy in the jacket?
Yes.
There's another video as well, Your Honor. The security provided the city as well as Mr.
And can everybody hear it?
Yeah, video and audio both working.
Okay. All right. So before we proceed, I'm going to set the stage. All right. This guy was arrested for filming in a government building in a public area That's the premise of what the video is about, and that's who the guy in the video is. Las Vegas Corruption Report is the name of his YouTube channel and the handle he goes by when he's out doing these audits. Okay? Now, what I want you to pay attention to is what is going on between the lawyer asking the questions and the witness on the stand in the next part of this video. And then I want you to pay real close attention to what the judge themselves says about how the defendant should ask his questions. So pay attention.
Audit a copy of all their cameras. We're not intending to admit all of them. And I'm just going to fast forward here just to lay a little bit of foundation. Do you see yourself in this video?
Yes.
I do recognize this video footage is 59 minutes and 15 seconds. We are not intending to play the video in its entirety. We are just intending to play portions of it, which we will timestamp as we go.
Okay, so it's not your intention to admit the entire video, only the portions that are going to be published?
Yes, Your Honor.
I would like the entire video admitted into evidence, not just portions.
24 hours later.
Are you aware of any video that was recorded in the interview room?
Yes.
Okay, and how are you aware of that?
I am aware of that from the video that I observed here today, as well as a request for video by the city of Las Vegas, which was preserved and provided to them.
Okay, so it's your testimony that they provided a 59-minute long video to you?
I don't know the exact time.
A 59-minute long video to you?
I don't know the exact time, but we did provide them with the video as it is preserved in its entirety.
Okay, so if you all provided them the video, why didn't you all provide me with the video?
Objection, relevance. Sustained.
All right, did you hear the question he asked the witness? The last thing he said.
My attention span is slow. Can you?
Yeah.
Listen again.
Provided a 59-minute long video to you?
I don't know the exact time.
A 59-minute long video to you?
I don't know the exact time, but we did provide them with the video
right here
as it is preserved in its entirety.
Okay, so if you all provided them the video, why didn't you all provide me with the video?
Everybody hear it? If you provided them with the video, why didn't you provide me with the video? That's what the defendant just asked the witness. Okay? And he got an immediate objection to it. And the court sustained the objection. Everybody understand where we're at?
Yeah, now it's time for the defendant to make a counter.
Keep that question in mind and see how this guy handles what comes next.
Objection, relevance. Sustained. Mr. Ott, why is it relevant?
It's relevant because he clearly just testified that he provided the video to them. They didn't provide the video to me. The video has highly damning evidence, which is a clear reason why they wouldn't give it to me. I had to subpoena it. I wasn't given the same thing.
Judge, he has the evidence. He played it for the court.
I had to subpoena it. They wasn't given.
Okay. If you want to find out things that are within the authority and the obligation of his office and their division, you can ask him those things if you have an obligation to do those things. But you can't ask him things that don't have to do with the events that occur.
All right. Now, does everybody understand what the judge said to him?
I believe so.
Okay. Based upon what the judge told him, rather than asking the witness, why didn't you, if you gave it to them, why didn't you give it to me? How should this defendant have formulated the line of questioning that follows up with the answer that about him giving the video to the prosecution? This is your first test of the evening. Real quick, think real hard about this, and this happens on the fly in court. You don't have notes. It's unexpected information. But since he knew that he was supposed to have the video, he could have planned for it in advance. But obviously he didn't. It was like the response took him by surprise, that being the defendant. Okay? If he had planned for it in advance to ask why he didn't get the evidence when it was given to the other side, then he would have had these questions already in place that he needs. But since he didn't do that and it caught him by surprise, now he's got to think on his feet in court. So, let me hear how you guys would create the next series of questions to figure out why was the prosecution favored over the defense in receiving this evidence. Now, keep in mind, we do not know if this guy ever filed a motion for discovery requesting the evidence. We don't know if he was even aware that the evidence existed prior to this testimony. We don't know. Now, we do, because they said he has the video, he has the evidence, he played it in court. But we don't know how he became aware of it. We don't have that information.
He said he had to subpoena it.
Right. But again, my point being that
he don't know how to.
He's making an assertion or an ask of the witness about why it wasn't just given to him rather than him having to subpoena it.
Yeah.
So we don't know what led up to this point as far as what he did or didn't do to get the evidence. We know that he eventually got it by issuing a subpoena.
Certain questions you would ask.
But if he really wanted to follow up on this, what questions would he need to ask about why'd you turn it over to them and why'd you not turn it over to us or to me?
Well, my question is, could he do kind of like a leading question to the judge?
It's cross-examination. It is a leading question. He asked a leading question.
Yeah.
Okay.
But the next question needs to be leading toward that, like.
Well, actually, I take that back. He asked an open-ended question rather than a leading question.
Yeah.
But the point is what should those questions have been, leading or otherwise? What should they have been instead of the one he asked that he got objected on?
All parties privy to information in a case, you know.
Come on, pretend you're the defendant. You didn't get the evidence that the other side got. Did you ask for it in advance or not? Okay. Did you ask for it through discovery or not? If you assume that you did things correctly through the rules of procedure and you filed a motion for discovery and then the other side got it but you didn't, how would you address that?
Can I ask who is on the stand testifying? Who's on the stand testifying? We don't know that, do we? Or do we?
It's somebody from the police department.
Okay, it is the police department. It is somebody. Okay.
That's who would have control of the video.
Okay, I don't disagree. I didn't know if they were just getting a video from the mall owner or somebody like that. These are all cops. These are all interested parties in the case, and an interested party is.
Well, they're either witnesses or part of the police department that's attempting to prosecute this guy. Okay. Like I say, he was charged with a number of charges because he was filming in a public building. Okay. And they arrested him for it. And then they tried to cover it up. And then they tried to create evidence that didn't exist to frame him for creating the crimes they were accusing him of. That's the general gist of why he's even in court.
Okay.
Now, why he doesn't have a lawyer, he requested one later on in this video, but everything he's done up to this point has been pro se. But my point here is that at this point, when he's asking this witness these questions, how do you plan for addressing what the witness testified to? Remember what we talked about. Foundation. Always start from a foundation. The witness gave you foundation in his response. The foundation doesn't always have to be a question or something that the prosecution's already asked about. A new foundation can be brought up based upon a response you receive from a witness during your cross.
Mm-hmm.
Eddie, can't he move to have something done since he's not, they're testifying on stuff that he's never had evidence of, he's never seen? Can he move to strike
No, he has the evidence. He eventually got the video. He had to subpoena the video. We don't know why he had to subpoena it versus filing a motion for discovery, etc., but we know that that's what happened. What I want you to focus on is addressing the testimony. Okay? How do we address the testimony? Better than, if you gave it to them, why did you give it to me?
Can I ask another question then? I mean, we don't know if he filed for discovery. If he filed for discovery,
right, I just said
that's
that.
A criminal act. We don't
we don't know if he
yet or not.
We don't know if he filed a motion for discovery or not. The only information we have is he eventually got it because he subpoenaed it.
I heard that, but it's a criminal act by the guy up there if they did not give him, if they didn't provide all.
Only if you can prove it was intentional and that it was secreted from him. That's exactly where you should be trying to direct your questions to figure it out on the record.
Gotcha.
So
if you're trying to figure out why give it to them and not give it to me, then you need to figure out what kind of questions you need to ask if you're trying to allude to the fact that you're treating me unfairly by ignoring my right to that evidence while you give it to the people trying to prosecute me.
You ask him if anybody else has viewed the video.
How does that help you?
it don't.
If your question is, why didn't you give me the video? Who else has viewed it help you? How does it help you? What's the relevance of that question?
Well, to show that they just kept it amongst themselves and not.
Well, the thing is we know somebody viewed it because he said he gave it to the other side. So we know it's been seen. So again, how does that question help you? We already know the other side got it and we didn't.
Yeah.
The question is, why didn't we get it?
Well, don't know if he did discovery.
No, the dogs are answering.
Yeah, the dogs are in there just being assholes again.
Because they're answering your questions for you, Eddie. You've got them trained.
Well, they're trying to. But I wish you guys were better trained. Come on, do this.
Yeah, but they hear you all day long. We don't.
And your point?
I've missed the setup, so I'm not sure what we're after here.
We want to know, other than the question the defendant on the video asked, which was, if you gave them the video, why didn't you give the video to me as well? And the judge telling him, or the other side objecting to that question and citing relevance, and the judge sustaining it, and the judge telling him, if you want to ask about what his duties are and responsibilities related to his agency in giving you that information, then you can ask him about that. Now that's a straight up forward point on where to start your questions.
Sir, do you not have a responsibility to give me the same information you gave the cops, or the same thing you gave them?
Okay, how's that anything other than a reworded thing that he just asked?
Well, we got to know if he had discovery. If he asked for discovery, then the cops.
Okay, again, then shouldn't you have a question about, did you receive a discovery request from me?
Oh, sure. Okay. And that's what the judge is basically telling him. Do you not have a discovery request from me?
No,
Yes.
that's not what the judge is telling him.
I thought he used the word discover. I thought he'd used the exact word discover.
He said you can ask him questions about his duties and responsibilities in that area relating to that thing for the purpose you're wanting to know, but you can't ask him that question because it's an open-ended question that doesn't serve a purpose. You think it sounds good, but what does it really get you? Why didn't you give it to me? Well, who says he's required to give it to you? What did you do to try to get it? Et cetera, et cetera, et cetera.
Mm-hmm.
That's why it's not a relevant question.
Well, see, when I had that issue, I had to go off of, okay, the state's claiming that this section, relevant subsection of this section of Texas Code of Criminal Procedure states this is what the state is claiming. However, based upon this, blah blah blah, these subsections have not been completed.
Okay, that's a different argument.
Right.
That's a statutory argument about what the discovery requirements are.
Right.
The point is, you don't have discovery requirements until discovery's been requested. If you never ask for that information, Texas has no obligation to give it to you. We don't know whether Las Vegas does or not. So what we have to do is formulate a series of questions that will let us find out.
Ask them directly if there's a policy that requires them to. What requires them to give it that information? Or a question that way. No?
Okay, let's assume a couple of facts just as a baseline so we can do this. Let's assume that the person on the stand works for the police department in the capacity as someone who maintains control of and the control and storage and maintenance of the audio video recordings made by the department through whatever source. Okay?
Did you receive a discovery request?
Okay. Again, obviously he received a discovery request because he turned it over to the other side.
From me, the defendant.
Okay. So again, how would he have received the discovery request directly from the defendant? When you file a motion for discovery,
usually it's
who
in
gets
the clerk of the court.
No, it's a motion he has to file.
Well, there's also a form in the municipal court that you would file with the clerk.
Yeah, but it still goes to the clerk, not to the person in possession of the evidence.
Right.
So how does it get from the clerk to the person in possession of the evidence?
Through a motion.
No, you made the motion. The court's not going to make a motion to procure evidence in response. And the thing about it is,
policy, isn't it?
the court is not responsible for giving you evidence in a case unless the case is against the court.
Was this a subpoena request or a regular discovery request?
He got it through a subpoena eventually.
Okay.
The question we're focusing on is, how do we ask our questions of the witness on the stand? You guys are making this way more difficult than it needs to be. Okay? You're trying too hard to be too perfect and too correct. Don't do that. I'm asking you very straightforward. You asked a question, someone objected, the court shot it down, and then gave you a course to steer to fix the problem and get the answers you need. That's what that municipal judge actually did. He gave him a heading and said, follow this and I'll let you go there. So
So
based
ask him
upon the
about his
follow
policy.
this, what should your line of questioning be to determine a response to the question you actually asked the first time?
Can you replay
Something-
what the judge just how he said it?
Would it be something to the effect of, did you receive my discovery request, and are you obligated under the rules of procedure to produce that discovery?
Okay, that's a compound question. Don't ever do that. Hang on.
The video has highly damning evidence, which is a clear reason why they wouldn't give it to me. I had to subpoena it. I wasn't given the same thing.
Judge, he has the evidence. He played it for the court.
I had to subpoena it.
Did we lose the feed?
Probably just wait.
I'm sorry, I thought I unmuted myself. I'm sorry.
Okay.
So, do we understand where we're at? He got the evidence through a subpoena. All right? We know he has it. He admits he has it. The prosecution says he has it because they know he got the subpoena sent in because they had to get served with a copy of it, right?
Yes.
Correct.
And they would have been the one that notified the police department to provide it, right?
Yes.
Okay? That's where we're at. Now listen to what the judge says.
It wasn't given.
Okay. If you want to find out, things that are within the authority and the obligation of his office and their division, you can ask him those things if you have an obligation to do those things. But you can't ask him things that don't have to do with the events that occur.
Okay, now that makes sense.
Okay? Things that he had a duty and obligation to do in his role or in his division. So, how and what would your questions be and how would you formulate them in order to get to the point you want? If you're trying to get to the point that I'm being treated differently because I'm pro se and I'm not being given information that would help my case, what questions can you ask the guy responsible for the videos that contain the evidence you need, but who didn't give them to you, to show why they weren't given to you except by subpoena?
You received a discovery request for the video from myself, did you not?
Is that where you want to start?
Something like that.
Well, that's the point. Something like that, or is that where you want to start?
Well, are we only talking about video? I'm a little lost at the whole thing of the case. But is it only one video, or is it all discovery?
It's videos from multiple cameras, so there'll be multiple recordings. But
Okay.
there's multiple cameras that made recordings of multiple things while he was arrested at the jail. But the one he's talking about specifically in this moment is the video of the interview that occurred in the interview room, where he was being questioned by police officers.
So you received a discovery request for the video of my interrogation or my interview with you guys in the whatever room, did you not? You'd have to say yes, right? Did you provide that video?
I'm sorry, I don't fully understand that question. Can you rephrase?
Did you or did you not receive a
Stop. Never, ever say that. Did you or did you not? Which one are they answering?
Yeah, good point. So I'll stick with my original. You received discovery requests for the video of my interrogation. Yes or no? Yes? Sorry. Yes.
I don't know anything about a video and an interrogation.
So what was it in that? Sorry, what was that video in that room that they're alleging?
What
that
room?
they're talking? Well, I'm speaking off the. I'm speaking not like we're questioning Randy. I'm trying to understand what video we're talking about.
I told you what the video is that we were talking about.
It was the police interrogation, I think, at the jail. Was that correct?
It was an interrogation in the interview room by one of the officers or a detective or somebody. but it's the video of him in an interview room, okay? So your questions need to spell out exactly what you were asking for, in addition to, did you get a request from me to get it? So you got to lay the groundwork on what it is you're even asking for, so it's part of the record.
Does your office and does your office hold contain records or hold the records of the video interrogations for that police station?
Again, I would refine that a little bit more, rephrase it, and try again.
Can I ask a quick question here? I mean, I'm sorry to keep asking these questions, but
that's okay. That's what the class is for.
You file a discovery motion through the court. The court is supposed to, the judges or
well, wait.
Archie, go ahead.
You file a copy with the court, but you also serve opposing counsel. The evidence is supposed to be in the gotten through the prosecuting attorney's office. But you have to tell the court, here's what I'm asking for in my discovery, and you tell the prosecution, here's what I want in my discovery.
And they've got, well, you got to be specific, or you say, I want everything that you've got in reference to this case. I mean, you can make a wide open stance and say everything.
And they'll object to that and go to court and say that your request is overbroad.
Or what they did in my case, they had the prosecutor's office, whomever that law firm was, send me like a 12 or 13 page certified return receipt mail envelope with their rebuttal as to why I didn't deserve to have a copy.
Okay, the point being that you can't be so overbroad as say, just give me everything. But you can't be so detailed as you forget something that you should actually be getting. That's a reason why there's specific ways to write a motion for discovery. For instance, you can say all audio, video, or other electronic recordings stored on any kind of medium whatsoever, or in any manner whatsoever. Okay. That's both specific and general. The recordings, right?
Yes, I agree with that.
Okay. I would like to have all records pertaining to the investigation by the police department, including any reports, any internal notes, any other documents associated with the investigation, or any recorded interviews associated with that investigation, or any other medium or implementation of any document relating to that investigation. Again, general and specific. Okay, I want this specific type of information, but I want anything that falls within that type of information. Understand?
Yeah, we're in full agreement. I mean, with this, I'm tracking, but I'm just not sure that should have all been done before they're ever walking in the courtroom.
Agreed. But my point is we don't know if it was done. Even if we assume, we're assuming for the sake of argument that it was done, and that even though and because he didn't get it, he went ahead and filed a subpoena to get it. So let's assume for a minute that he asked for it twice. One through a motion for discovery and one through the subpoena. And they only responded to the subpoena. Now you have to find out why. So how do you ask your questions of this witness to get that into the record, that they intentionally tried to withhold evidence?
So the direct question would be, my motion for discovery, I have requested all video, electronic instrumentation, everything.
Objection, relevance. The witness hasn't seen or read the motion for discovery, and the defendant's now testifying.
Well, the defendant's the one that put the motion for discovery in.
I understand
he's
who
pro
put
se,
it in,
right?
but it doesn't mean he gets to stand up in court and testify about what's in it.
No, he's asking the witness, did
The witness hasn't seen his motion for discovery. How could the witness answer the question?
have you seen my motion for discovery
The
request?
witness will never see the motion for discovery. They're not part of the court and they're not part of the prosecution.
But maybe I'm lacking or just don't understand how the law is supposed to work. Because the courts, I mean, all the law that I've read over years is the court is there to get to the truth. And if
that would be nice if that's all they were there for, but it's not.
But they, and they don't do it in any way, shape, or form. But the court has a responsibility if somebody is basically just trying to hoodwink this dude in court by withholding exculpatory evidence. That's criminal.
Okay, point taken. Not arguing with you. My question to you is how do you get that on the record and before the court to look at it? You're assuming the court already knows they're doing it. That's not true. So the goal here is to get it into the record that that's what they're doing. How are you going to do that? It can't be the way you're trying to do it now.
Were you instructed not to provide me with this, with what I requested in my...
Again, that's not laying a foundation to get to that kind of question.
Okay,
you laid no foundation for that.
Should we start with the records they actually keep, the request for those records, did he receive it, etc.?
Okay. Okay, stop. You've watched the video. You've heard the testimony. So you already know what they do or do not know about there being video. So yes, we know that this is the guy responsible for keeping those records. We know that this is the guy who provided those records to the opposing counsel. So we know what this witness's job is at the place where the records are kept and what he did with those records.
Gotcha.
But we want to know now is why we were not a part of that process. Now, if we assume that we filed a motion for discovery and then we had to subpoena it because our motion for discovery was not responded to, and who would have had to respond to it? It isn't the witness. Who is it?
Will be the DA, but the DA would
The
have
prosecuting attorney would have had to have directed the witness or the person in charge of the evidence to send you that information, wouldn't they?
Would the prosecuting attorney also have directed the original discovery to them as well?
They should have, yes.
Should have, right.
Okay. So we start. I go back to what I said. Do you keep records of all the interrogations in that on the police station? You keep video records on.
Okay, again, you haven't laid a foundation to get to that question. Let's pretend that this is your first question that you're going to ask this witness, and you need a foundation to start from.
I don't know what you're after. I'm sorry. I don't know which that's supposed to be.
That's what I'm trying to get you guys to reason out, okay?
They hold videos.
We know who the guy is. He testified that he gave video to the other side, right?
Yep. So you testified that you actually had you retained records and video of the interrogations in that police office. Yes? In that police station.
Okay. Yes, we know he testified to that. So what's going to happen right there? Objection, asked and answered. Or objection, already been answered through prior testimony.
Do you hold the record of my video interrogation?
Well, we already know that's the same thing because that's exactly what he said he turned over to the other side.
Did you receive a request for that video of that interrogation?
Okay. What did the judge tell him to ask about? Duties and obligations
and their
in his role or through his or by his agency?
Were you instructed by the DA not to?
No. That's being antagonistic, and there's no base for that yet either.
What is your duty when a motion for what is your duty when you receive from the prosecuting attorney this motion for discovery? What is your duty once you've received that?
Okay. My duty was to provide them with the information, which I did. I just testified to that.
Provide them, but
they're the one that filed the request for discovery.
I was the one that submitted the request, the discovery request.
And different question. That's not what you asked. That's not what you asked.
Did you receive my discovery request from the prosecuting attorney?
That's what I said. Did the prosecuting attorney do you have my request, my discovery request? You made it, and what is your duty?
Okay. There are two baseline questions you could have asked at the very beginning based upon this answer. Okay? You've obviously already asked a question, but this is the answer you've got, and now you need to address it because you think it's going to lead you to the fact that they were hiding evidence from you. Okay? So from my perspective, there's two questions you can ask to establish your baseline for proving that. Okay? One is to start with, all right, so just so I'm clear, you are the person that is responsible for maintaining and responding with those recordings to any request for that information for use in court. Through discovery motions, subpoenas, that's your responsibility, correct? That's question number one. Question number two, okay? So just so I'm clear, you're testifying that you are the one that provided copies of that video to opposing counsel. Does that mean that you are the person who is responsible for accessing, maintaining, and responding to discovery requests relating to those recordings in that jail or in that police station or in that department? They both wind up in exactly the same place. They're just worded differently and approached from a different angle. Everybody agree with that?
Yep.
Yeah.
Well worded. Your question is going directly to the point. I agree.
Okay. That's what I mean about think before you speak. All right? Listen to what's going on, analyze the facts in front of you, and figure out how to fit them together to get to the next step and what you need.
Sure.
Now, what will your next question be based upon either of those, since they both get you to the exact same point? What is your next question? Now remember, the motion you filed or the subpoena you filed did not go directly to this witness on the stand. They went to the court or through the court, and then a copy was given to the prosecution, who is then responsible for responding to the request or the subpoena.
So now would we insert that question? Did you receive my request for discovery from the prosecuting attorney? Since you are the custodian?
There you go. Now you've laid your foundation question to get to that question. Did you ever receive a copy of the motion for discovery filed by the defendant in this case? Don't say me. Keep the record clear. Did you ever get a copy, or were you ever told to provide copies of that video in response to a motion for discovery filed by the defense? Because remember, he won't get the motion. He'll just get the information ordering him to produce a copy and send it here to whatever address that may be. Everybody agree with that question?
Full agreement. Yeah. Okay. Is the DA a prick or not? I mean, that's where we're at.
Now the next question. What is your next question? Let's assume. What does he say?
Did he say yes or no?
No, that's right. He can only say yes or no. So let's look at what the possible route each one of those answers takes us on before we ask our next question.
So he says yes. Do you have a duty to provide that information to the defendant, to the whoever initiated that discovery motion.
Okay.
Do you have a duty to do that?
Well, again, whether he has a duty or not doesn't tell us whether or not he did anything to do it or not do it.
You should probably ask, do you have a duty to disclose that if you do receive a request?
Well, let's say that he says yes. What's your follow-up question?
If he says yes, I do have a duty to provide that.
No. Were you ever informed of a request for a motion for discovery request by the defense in this case for that video?
That's what I asked.
Let's assume that he says yes. What is your follow-up question?
He says yes. Do you?
And did you provide that?
Did you provide that? There you go. Short, sweet, and to the fucking point. Did you provide that? That's all you got to ask. It doesn't have to be complicated.
Maybe I'm confused. Who does he has to provide that to, the defendant, or does he have to provide
If he received information that there was a motion for discovery from the defense, he would have been given the information on who to send it to and where.
By the district attorney.
By the district attorney or the prosecuting attorney,
right.
Whoever that is.
Right. So if he said yes, that means he got it. He had, at that point, the duty is his, not the prosecuting attorney's, right?
Right. Once the prosecuting attorney informed him that he had a request for this and he had to give it and told him where to send it, then the question is did you respond to that?
And I agree with that. And yes or no is
and then there's going to be a yes or no to that. But now let's back up one step and let's say that he says, no, I didn't get any information about a discovery request from the defense. Now what's your follow-up question?
So just to be clear, you're saying that prosecuting attorney, the state never gave you a request. Clarify, right?
Okay, again, where's your foundation for showing the state ever received the request?
You'd have backup copies.
Unless you get up there and testify that you filed it and they got it, how does this witness know the answer to that?
So what you're saying is, you should have put your discovery should be within the evidence of the case, correct? Isn't that part of the transcripts?
I don't understand the question.
Well, but when all motions, everything that goes through for cases is part of that particular case. So
yeah, if they're actually keeping transcripts, which they don't always do, especially in these lower courts.
Okay,
the case file is the actual record for the stuff you're talking about, what's been filed, etc., etc. But what you don't know is what happens to the stuff after it's been filed. You don't know what the prosecutor does with the documents you send them. You don't know if they respond to them or not until you don't have what you asked for, or they don't reply by the deadline.
Right.
So you don't know.
But they have specific duties by law based on everything submitted through the courts, correct? Or they just do whatever the hell they want to do?
They have duties based upon what the code of criminal or the rules of procedure say they're required to do, whether it be criminal or civil rules of procedure. So the question here is we're trying to show that the prosecution didn't comply with the rules of procedure by forwarding us the information that we requested through the motion, or they're intentionally hiding it. That's what we're trying to get to. But you can't just come out and accuse them of it. You better have a way to fucking prove it.
Yeah. And it basically, you're using the Socratic method pretty well. It's just I'm trying to think of how it's hard to follow a thought process without knowing everything that's gone down and what
Agreed.
This guy did.
But this is not supposed to be you trying to follow my thought process. No. I'm giving you the situation and the circumstances, and you're supposed to use your thought process to figure out what to do. And my job then is to say, okay, If you do that, then how does that affect what you're the outcome of what you're expecting to get?
So at this point, the guy on the stand has said yes or
Nope,
no.
we backed up. Correct. His response would have been yes or no to the first part about were you ever informed of a discovery request by the defense for copies of that video? We got it. We walked down the first step of our yes answer. Now we've backed up and want to walk down the first step of our no answer. And we haven't done that yet. So somebody come up with the response to a no.
So for that, were you provided with a request from the defendant by the prosecuting attorney?
We already got that. That's the question that got us here. That's the same question we just asked to get the yes or no that we now need a no for. We want the answer. We want the next question to follow up with the no.
Yeah, in my brain, your little diagram is starting to appear in my head. That's once you go down your cross-examination, it's yes, it happened, you move here. No, it didn't happen, you move here.
Correct.
And that's so helpful.
It's a flow chart. Okay? It's a freaking flow chart. Except you're having to make this one on the fly.
Yeah.
But there's always a logical next step based upon what you've got so far. So now the question is, what is the logical question to ask if we get a no response to the question, were you ever notified of a discovery request by the defense for a copy of that video? What is the response or the next question to a no response to that question? What's your goal here? What are you after? If your goal is to prove the prosecution is intentionally secreting evidence and not providing discovery, what should you be asking this witness?
Well, if he said no.
So whoever was responsible for getting it to him did not get it to him based on that no answer. Does everybody agree with that?
If he didn't receive the request, then he's off the hook. Right?
He's out of the hook. So when he says no,
right, which puts who on the hook?
The
prosecution.
Exactly. So what's the fucking question?
Did the prosecutor provide you with the information and the motion?
The request.
Or the request?
Wrong.
That's what I
That's
said.
a reword.
No.
Stop. That's Helen, that's a rewording of the same question.
Oh, okay.
Did you receive the request from the prosecution?
That's the same question.
And he said no.
So what other questions could you ask beyond that?
If you had the evidence showing that you did file...
okay, let's try this. Okay, just so I understand your testimony, are you saying that the motion the defense filed with the prosecution did not result in a notification to you or your office to provide a copy of that video to the defense?
Mm-hmm.
All right.
And if he says no?
No, that was the question you asked after no.
That was his answer.
Yeah.
No.
But if you clarify it and he says no again...
You're clarifying his answer.
Again, no's not the answer you want to get to what I just asked, because that means no, that's not true.
So no, I'm not saying let me hold on just a minute. You just asked the question you said is, am I to understand correctly that you did not receive a request for discovery, a motion for discovery for the
notice of a discovery request for this video evidence? He won't. This guy will never see your motions. Stop wording your questions that way. You're giving the prosecution a way to object. Never ask the witness, did you see my motion?
Yeah.
Of course they didn't see your motion. Not unless you're suing the court or the prosecution.
Yeah, because they don't even see the damn laws they tie you under either.
Okay, so how you word your question is important.
This.
Okay? were you ever given notice of a discovery request by the defense for a copy of that video from that interrogation room? Now, if he says no, then he's lying because he can't give you the same no twice.
Yeah.
Uh-huh.
Wait, since can you say that again?
Okay. Did you, were you ever given a copy of a request from the defense for this video? That was our original question, right?
And he said no to.
And he said no. Is it your testimony that the prosecutor did not give you the information regarding the defendant's request for a copy of that interview room video?
Okay. If he says
and if
no,
he says no again,
okay,
we got a fucking problem.
He's lying.
Yeah.
Right. Okay. That, I agree.
And now we got to create the next question to trap him.
Right.
You've already trapped him.
Well,
you did, because you can't get no to both of those questions.
He's cooked at that point.
Well, no, we need to glue his ass down like a rat where he can't get out.
Okay, so let's just, for shits and grins, say that he says no. I'm sorry. First, you testified, just so I'm clear, you first testified that you never received a request, but you're also saying that you did get information regarding the request from the prosecutor? No. Well, you can't have it both ways. Either you never got the original request, and therefore they didn't forward it to you, and you would have had to have answered yes, or you're outright lying on the stand right now about what happened. Which is it?
Yep. Good time to impeach that witness.
Okay? There's the issue. Now, let's back up and let's say that he says yes in response to that second question. Yes, you are correct. I never received information from the prosecuting attorney's office about an information or a discovery request for that interview room video. Now, what do we ask?
Well, at that point, isn't it time to put the motion on the record and say, Judge, just put the motion, I want to make sure this is part of the document. This was filed with the prosecuting attorney on this date and yada, yada, yada. And the request was made through the system, all the proper procedures, the technical aspect of all this idiocy. Pardon me, but I mean, I get irritated. We don't want to know the truth. We just let's go through all the technical things that can get your butt thrown in jail.
No, we use the technical things to arrive at the truth. That's the difference. We can still get the truth, but the stepping stones to getting there freaking matter.
Yeah, I mean, I don't disagree with that, but it's from a pro se perspective, it's just extremely difficult.
That's because most pro ses don't learn the freaking rules and they try to wing it like this guy was doing, and that's the problem.
Right, I don't disagree with that.
Okay, so here's what I would do. My third question would be to give him an opportunity to double down on one side or the other. Now it's a lock, okay? So let's say that he said yes, that he did receive the request on what to do with it, okay? And now we go, okay, so why then was the defense not provided with the information you clearly acknowledge receiving a discovery request for? Now that's not a leading question by a long shot. We left it open-ended. And here's the problem. What did I just ask the witness?
To impeach the prosecutor.
No. What is the one thing I asked the witness? I just told you. How many times have I told you? You never, ever ask a witness what?
A leading question, a compound question.
Yeah, or an open-ended question.
Well, again, we know it's open-ended, but it began with what?
Did you? Is that what you said? Or
No.
why? Why?
Why? You never ever ask a witness why, unless you know absolutely 100% for certain what the answer is going to be. You never ask a witness why. This is why I tell you guys, every question must be a leading question. He could say anything in response to why, and that may or may not get you the lock that you need. Correct? Everybody agree?
Yeah, I agree with that.
Yeah.
So how then should we word that third and final question to lock this in, that we were intentionally denied our discovery?
What happened?
No, that's an open-ended question.
No. In my brain, I know this won't work, but what stopped you? That's like, I know you can't ask
That's
that.
still an open-ended question.
Yeah. Because it's open for anything.
Right. We want a yes or no, or true or false.
Were you instructed not to provide the
No.
respond to the request?
Again,
Ask him
he just testified that he received it. You haven't laid any groundwork to get to whether or not he was directed to do something other than what he just testified to.
And did you give
He acknowledged receiving the request.
And did you fulfill all the requests to all parties?
If you said
Okay, here's your two questions, guys. Come on, think on your feet, guys. Okay. Based upon the fact the defense did not receive the evidence in question, you did not respond to that request for information by the defense as it was given to you. Is that correct?
There you go.
Yes, that's correct. Is that because you were instructed not to do so by the prosecuting attorney's office? Or is that because someone instructed you to not provide a response? That's a less aggressive and accusatory way to ask it. That's my two follow-up questions to that. Okay, because he just said you didn't get it, we didn't get it, therefore you didn't respond to it, did you? Now he can still say yes he did. Then where is it? Why didn't I receive it if you did? Let's say he does that. How do you verify that you should have gotten it and you didn't? Therefore he must be lying. How do you verify that?
Do the procedures identify that they got to be certified mail? I'm not sure.
Does the rules say that you have to be given evidence through certified mail?
That's what I'm asking. Do the procedures say that
Again, you're asking him about procedures under the rules of evidence and criminal procedure. He's not a lawyer. He's not on the prosecution's team. That's not what he does. He's not going to have an answer to that.
Yeah, I'm asking that question.
Again, it can vary by state as to what's required.
Okay,
so there's no way to answer that.
So that's on the procedures of that particular jurisdiction.
And we don't really care. The question goes to why, if you got it, why didn't I get a response? Okay? So, what's our question? If he says, yes, I got it.
What?
Yes, I got it. Okay. What did you do when you received it?
There you go. That's a good follow-up.
Yeah.
How did you respond to that request?
Thank you.
Now, again, that's not a leading question, is it? Neither of those are.
No.
But occasionally you get a response where a yes or no is not going to get you much further. How would you ask a yes or no question in response to that?
Well, if you answer no.
There's only one you could have done. And did you respond to that request as you're required to do? Yes. Now, you still don't have a way of explaining how. How do you ask a yes or no question to the how? So there are times when you're not going to be able to ask just a leading question. And now you've run face first into one.
Yeah.
He did. Well, you just said he just said that he did respond to that request.
But we don't know how he responded. We don't know what he did in response.
I agree.
Did you?
So how do we find that out to make it part of the record and do it with leading questions?
Was your response to the defendant?
Okay, let's first make sure that the information he received was accurate. How about that?
Good.
Do you recall the address to where you were directed to send the evidence in question? Again, yes or no?
Step by step by step by step. You got to walk them through it.
Exactly. Do you recall the address? Do you have it on your paperwork? Do you have it in your notes? Do you know where you were directed to send it? Yes or no? Now, depending upon which one he asks. Okay? And again, if you subpoenaed this guy to appear and told him to bring his records, he should have his records of what he did one way or the other, including what the address was he was directed to send it to, right? That's why they have subpoena duces tecum.
Ask him if he can provide the record of how he said that.
No, that would be asking for evidence that you don't have a right to at this stage of the trial.
Okay.
This would have had to have been something you had in advance.
Okay.
This would have had to have been something you received before trial. So, either you would have made the request to get a copy of the records that he has as to what he did with the response, or you're going in there with nothing and you're trying to get him to testify to it.
Okay.
So for the sake of argument right now, let's assume he's going in there with nothing as far as that record is concerned.
Eddie, can I stop one more time? You just, if I understood what you just said, so you put in a motion for discovery, and the guy put in a motion for discovery. He got some of that information, is what you just said? He got some of it, but not all of it?
No, that's not what I said.
Okay, I thought that's what I heard you say.
We're following up on what he did in response to the request for the discovery. Okay?
Right.
We asked him if he recalled what address he was directed to send that discovery information to. Okay? And he should have that information in his records as far as the direction he got on the discovery request. But if you didn't do discovery to get those records, you won't have a way to say, well, let me refresh your memory, or here's the date and time according to your own records, because you don't have them, right? Because you didn't think to ask for them. You didn't know who to ask for them. You didn't know they were required. Whatever reason, you don't got them. So now you're having to feel this guy out without supporting paperwork to force an answer out of him. So you've got to tread carefully to get the answer you need. All he can say is, yes, I remember the address, or no, I do not. At that point, you can ask one more leading question. Does such and such address sound familiar? And again, he can say yes or no. If he goes yes, then you can continue. Do you recall whether or not that is the specific address relating to the request for this? Again, he's most likely to go yes or no. And if he goes no, at either one of those 2 points, stop right there. That trail has run cold. There's nowhere else to go. Now we need to back up and take a different branch off and try it that way. Everybody agree?
Yes.
You've hit a dead end because you don't have actual paperwork to use to force an answer that will help you. That's the difference between going by argument and going by evidence. With the records, you can force an answer and continue down that path. Without the records, it's a dead end at that point.
Gotcha.
Does everyone understand why?
if his own records prove he's lying, then you're doing a pretty good job.
You have no way to prove what any response he gives you after that point is true or false. Right. You have no way to prove it
with no records from,
and you have no way to continue it.
Got you. I agree. That I can understand.
Okay, so why beat a dead horse?
Feels good.
Doesn't do a whole hell of a lot for the horse, and it doesn't do a whole hell of a lot for the people watching you beat it.
I'm just frustrated.
Like the jury.
Yes, exactly.
Okay? Or the court if it's a bench trial.
Yeah.
Okay? So, don't do it.
Oh.
Realize you're at a dead end and back up. Let's try a different tack. So, let's go back up to the question where he says, no, in response to the first or the second question about, did you receive this request? And we follow up with, are you saying that the prosecuting attorney's office did not provide you with a copy of the discovery request I submitted to them?
Yeah.
Remember, he can't give you no a second time. All he can say there is yes. So now when he says yes, what do we do next?
Judge, you're going to lock the prosecuting attorney up.
Well,
that should be the question.
No, that should not be the question. There should be a question. Actually, there's
duty. If the prosecuting attorney is not complying with discovery, isn't he committing a criminal act?
Yeah, but you got to question him first.
Again, yes, he is, but this is in a court. It's not let's accuse each other of shit or let's make a deal. You're in court. How do you make the court work for you and not against you in this situation that we are now finding ourselves? We have a witness who just testified he was not given a discovery request that was properly filed with the prosecutor's office, putting the prosecutor on the hook for not giving it to them. What do you do with that information? How do you use it?
Motion to dismiss at that point.
Premature. You haven't given the court a valid reason for the dismissal because you haven't requested the court to take notice of anything. You haven't asked the court to move the court to do anything. What is the basis for requesting a dismissal at this point?
Yeah.
This is where the layman has a hell of a time. You know that the prosecuting attorney's lying. You know the judge has a duty.
No. The prosecuting attorney hasn't lied about anything.
He's not doing his duty. He has a duty.
We know now, based upon the witness testimony, that the witness never received any information regarding a discovery request for the defense from the prosecution. That's what we know. Do we agree?
Yes.
Yes.
Now the question is what? It's the question we can't ask, but it's definitely the question.
Why wasn't he given?
Correct. Why didn't you get it? We can't ask that question. Not of the witness.
Nuh-uh.
Right.
So what do we do with it to make it useful?
Let the record show that the witness never received my request from the prosecuting attorney. I mean, right? Isn't the record already showing that?
Who are you saying that to?
To the judge. Let the record
say it that way. Judge, I request the record reflect that the witness has just testified the prosecuting attorney never provided my discovery request to them for that evidence.
Amen.
Sure. Okay.
Yep.
It's official. It's part of the record now. Now what do we do with it?
No more questions for the witness.
Well, what do you think the prosecutor's going to do when that gets brought up?
Objection.
Again, you're not thinking in a courtroom environment, people. Do you think the prosecutor's just going to sit there and take that? There's only two things they can. There's three things they can do.
Motion to dismiss.
Stay silent, which is bad enough. jump up and call their own witness a fucking liar,
We'll dismiss it.
or what's the third thing?
Strike it from the record.
No.
They can try to argue why they didn't do it.
Mm-hmm.
They can try to make a fucking excuse.
But all they're going to do is just pull at straws like they normally do.
Again, not the point.
And you can see it happen in real time.
Yes, but not the point.
Yeah.
Okay? So, whichever one of those three options they take, let's see what to do there. Let's say the prosecution remains completely silent and doesn't address it at all. What do we do now?
Move the court to
Let's look real quick at one of the due process rules regarding silence. Who has the right to remain silent?
The defendant.
defend.
Does that right apply to the prosecution?
No.
No.
So, is it a legitimate legal rule that you cannot use the defense's witness or the defense's silence against them in court?
Is it a rule that you cannot?
It's a tentative due process. You cannot use a witness's refusal to reply or respond to questions, meaning their silence, as evidence of they commit against them in court.
That's Fifth Amendment.
Yeah, Fifth Amendment to remain.
Okay, so that right does not apply to the prosecution, however, does it?
Right.
So we can raise the issue of the fact the prosecutor's not addressing this, can't we? That they're staying silent.
Sure.
So how do we do it?
The witness is no longer on the stand, or is he?
The witness is still sitting there. The witness hadn't gone anywhere.
Okay, so but you're not addressing the questions to the witness at this point.
No, we're talking to the court while the witness is still there because we're asking the court about something based upon that witness's testimony.
Basically, Judge, are you going to allow him not to talk?
Again, no, not the right way to word your question or whatever it is you're going to put forth. Should it be a question or should it be something else?
Could demand a recess and call the prosecution and for questioning?
Whoa. Why would you want to recess at this juncture?
You're going to move the court to, you're going to move the court demanding them that they make that prosecution provide that evidence. But you got to put it in a way that moves that court to do so. Am I on the right track here or not?
Sorta, kinda, almost.
Almost? Okay. Well, I'm glad.
Yes, you want to address something with the court about the prosecutor, but the question is what and how.
In my situation, it would have been to place sanctions on the prosecution for not following through on blah blah blah.
Again, what's your basis for the sanctions? You haven't said anything yet that creates the basis for the sanctions.
I get that. So this would have to be, in order to create those questions appropriately, then the defendant would have to be well versed on the statutes and codes that are required of the prosecution or the other side.
Well, not just the statutes and codes, but case law too.
And constitutional law, both federal and state. It all ties together in para materia.
Okay, no one's given me an answer to what I asked, though. I'm glad everybody's explaining to me how it works. Thank you. What's the fucking thing you do?
Well, that I'm thinking about. Give me a minute. My fever's breaking.
Y'all had 10. You've had 10. Come on. You're not going to get this slow roll shit in court.
Okay.
Do you move for a directed verdict?
That's why we're here.
Why would you move for a directed verdict? How do you get a directed verdict at this juncture based upon what we know?
I don't know. I tuned in late. My bad.
A directed verdict is at the end when the state rests and they haven't proven their case. That's when you ask for a directed verdict. How do you get to that from here?
You got to go through all the steps first.
No, the answer is you can't.
Yeah, that's what I'm saying.
It's not the proper time to be asking for a directed verdict. Period. The witness just testified that they did not receive the discovery request from the prosecution. They then doubled down on that and reaffirmed they did not get it. Okay? We raised that to the court.
You're not getting a fair and important.
Okay? The prosecution chose to not address the witness testimony. What do we do with that? How do we turn their silence against them?
Let the record show prosecutor's silence.
How does that help you?
Well, I mean, he's not refuting that he did not forward the request as he's required.
That doesn't answer the question of why.
I'm not saying why. It doesn't matter why. As far as I'm concerned, he's sitting there being silent.
Again, it may very well matter why. Let's say the prosecution immediately jumps up and goes, well, Judge, we never received that request. Or the request was lost in the shuffle of paperwork at the office.
Well, that's not right.
Let's say the court turns to the prosecutor and says, why didn't you do that? And that's one of the two responses he gets.
You said the court just turned to him and did that? The judge did?
Yeah, after you said, let the record show that the witness just testified they never received my motion for discovery request from the prosecution, Judge. I want that on the record. Okay? The prosecutor initially says nothing in response to the testimony or what you just moved the court to do. Now what do you do with it? Let's say you ask the court to say, or the court takes it upon themselves, sua sponte, to turn around and look at the prosecution and go, sir or ma'am, can you please tell me why he never got that request for discovery? And he gets one of those two answers. Now what?
He get one of those three. Silence?
No, that's to the first part. When we said, let the record show that the witness testified that they never received the request. That's where the prosecutor can be silent, argue, or call their witness a liar.
Right.
Now, after that, let's say that he chose silence in response to that request, and the court then turns to them and says, how about it?
The court did that. Okay, so the court asked him, what did you not do?
And now the prosecutor gives them one of those two responses. It was lost in the paperwork, or we never got it.
That's when you provide paperwork showing that it was submitted.
What paperwork?
A motion for public records request, or for information, for your discovery, or.
Well, okay. Again, how does you having a copy of the motion for discovery prove they got it?
The clerk.
It's file stamped by the clerk.
That's file stamped with the court. That doesn't mean you serve the other side. How do you prove you serve the other side?
You still have them served, or it's a return receipt
certificate of service on the back where it's stamped.
What is in every motion that I have given you guys a copy of?
The letter of transmittal is typically.
Oh, at the end, it's the notice.
At the very end, there are two things at the end of every motion I've given you guys. What are they?
Yeah, it's the back end of it. It's
the notary signature.
One is the proposed order, and the other is proof of service.
Thank you. That's the name of it. Yeah.
Okay.
So if you served them, what should you have had them do when you served them?
Sign.
Sign for the fucking service.
Yes.
So when they raised that issue in court, we never received it. Objection, Judge. For the record, right here, the court has a copy of my motion that I filed and I served the prosecution. Right here is my signed receipt of service from a person in the prosecutor's office named such and such.
Yes.
Does that person work for the prosecution?
Yeah.
Okay. So you got your proof of service. You can prove that they received it. So now let's say the response is, and they know they received it, and they know you got proof, so now they go, it was lost in the paperwork at the office.
I know. The other thing, this might sound offbeat, but like when you're going through, your case or court, whatever, and especially if it's like a county court, and it shows like when you go online and you can see all the things that's been submitted and entered into. Filed with the court clerk. I'm sorry.
Again, that's the court records. It doesn't have anything to do with what the prosecutor's office received.
Everything's a signature for service.
Okay, that shows you what the court knows was served to the court. Doesn't mean the other side got it.
But when you serve it to the prosecutor, you also get the notice of service.
Right, we established that. Anybody you serve, you get a signed copy. Even the court, you get a file stamp and or a signature from the clerk of the court where you filed it.
Understood.
Now, back to my question.
Okay, go ahead.
The question being, it's lost in the paperwork shuffle at the office. We're so sorry. It was accidental. We didn't mean for it to happen. We didn't know that this witness didn't get a copy.
So they're acting with reckless disregard.
How do you prove reckless disregard?
With what he just said, we don't know.
Again, you're okay. That's a separate issue. You're not trying to prove anything at this point.
Okay.
You're trying to set your case up for your benefit. So how do you use that response from the prosecution?
How's that my problem, Judge? Right? I mean,
well, obviously it's your problem because you didn't get the discovery. You didn't get evidence you were entitled to. That's why it's your problem.
So the defense is...
Wait, stop.
Go ahead.
Pastor, think about this. The way you worded your question, I responded to your question appropriately, and it didn't help you. Right. What does that tell you about your question?
Let the record show that they lost the paperwork.
No, you don't know that. Right. They just said it was lost in the paperwork at the office, but that still doesn't say anything that helps you. It's already in the record. They just said it on the record. How does that help you? Come on, think, guys. The prosecutor just admitted we didn't give the request to the person that holds the evidence. Here's our excuse for why. What do we do with that? We're in the middle of fucking trial. What do we do with it? You can't testify about what's in the evidence unless you get on the witness stand. You can't testify you didn't get the evidence at some point because you did. So what are we doing now that we know the prosecution never gave the person holding the evidence the request to provide it to the defense? We've got it in the record that the witness testified that's what happened. We've got silence from the prosecutor until we asked the court, or the court sua sponte addressed it and got one of those two responses. We've addressed the first one. Let's address the second one. We lost it in the paperwork shuffle. What do we do with that? I can only remind y'all of where we're at so many times before somebody's got to answer something. Come on, give it a shot. There are no wrong answers. There's just ones that will or won't help you at this point.
See, the problem I've got is their incompetence is not an excuse. I'm sorry, but
now you're being combative.
In my business, just hold on a minute, because what you're doing is technical aspects of the way the court system and way the process works. And for me, if I went to my customers for the last 50 years and said, sorry, I lost it, I ain't going to have no customers.
That's true, and you'd be out of business, but that's not how it's going to work at the prosecutor's office.
And that's
they may fire somebody, but that doesn't stop the prosecutor's office from prosecuting you, does it?
The people need to. Well, I don't disagree, Eddie. I'm just
okay. My point here being is
if they have anybody that looks for the paperwork. You know,
Okay, the point here being we need to address the response by the prosecution with the court. How do we do that? Get your ass in court, in your mind, and answer the question. How do we do that?
I've got a signature. What I would do is call whoever signed for that notice of delivery.
That doesn't mean the person who signed for receipt of your motion is the person responsible for forwarding it to the witness.
I agree, but you can
Okay, then what does that get you?
Who did you give it to?
Who give it to?
I want to follow the chain of the
You
chain
can't
of
put
custody.
one of the prosecutor's personnel on the stand for this. They're not going to let you call that person unless you already had them on the witness list and you didn't know who the fuck it or that this had happened until just now.
Eddie, I'm sorry. The system is so freaking corrupt.
No. Stop. Listen.
It is. It's so
this is about you. This is about you having to go off being caught with something new in court and building upon it.
I understand.
Okay, that doesn't make the court or anybody else corrupt. That means you don't know how to get where you need to go to use it properly. That's what I'm trying to teach you here. That's what I'm trying to get you to answer to. How do we use the information we just got out of this witness? We got it into the record. We got it before the court. How do we fucking use it?
Tell us.
I have no idea.
I got a million thoughts, but I'd like to hear.
We lost it in the shuffle.
When did you become aware you lost it?
There you go.
Okay. Thank you, Helen.
Judge, the defense would like to know when the prosecution became aware that they had lost it.
Yeah.
Was it before the witness's testimony or just now because of the witness's testimony?
That's what you call a fever break, folks.
Okay? Now think about that. You asked that question that way, now you've got them between a rock and a fucking hard place. If they knew it beforehand, they should have fixed it. If they knew it only when the witness testified to it, then how the fuck can they sit there and say they lost it in the paperwork at the office?
Yeah.
They're fucking stuck.
Yep.
How many years you been sitting in courtrooms? I'm just curious.
Too damn many, obviously.
It's the process. I mean, it's
exactly. And everything about the process, Tapster, this is what you need to understand. Everything about the process is meant to make the record for the appeal. What we're doing here is making a record that proves to the appellate court we were railroaded and denied due process. Now it doesn't matter win, lose, or draw at the trial level. We've got it in the record. We were screwed. The prosecution was part of the screwing, and they damn well knew it. Yeah. And it was intentional, one way or the fucking other. That's our record going up on appeal. Do you think they want this to go to appeal at this point?
No.
No. Because when they do, somebody's ass going to wind up swinging from a tree.
Yeah.
And it ain't going to be the defendants.
Somebody going to get it.
So now we've used that information we got from this witness to impeach the prosecutor of all people about why I didn't get my discovery. That's what the judge was telling him to fucking try to do. And that, ladies and gentlemen, in my personal opinion, there's probably some people that could have done it better. But that's how I would have done it, and that's where it would have got me.
Yeah.
Understood. Just thinking on your feet is the way it is. Dude, do you know what happened with this guy?
I think his case is still ongoing. Because they've shuffled him in and out of this court half a dozen or more times at this point. They'll call him in for a hearing just to have a different judge sitting up there saying, I'm not going to rule on anything because I'm not the regular judge. And then they'll send him back out again and schedule him for another date. They just keep harassing him and making him go back and forth. He's already raised the issue to this judge that this was a malicious prosecution. This is the appellate judge he's in front of right now. When he's wearing this outfit, he's in the appellate court raising these same issues. But the problem is, what does the record show for the appellate court to review? If he didn't do the things that we just talked about, none of that's in his fucking record. If it's not in his record, the court cannot address it. Right? The appellate court can only go off the trial transcripts and the evidence and the filings that were made in the trial court. They can't take anything new.
Nope.
So if he didn't get this in the way we're talking about, he's screwed.
Yeah, you got to have it on the record.
Right. That I've always understood that. But
well, this is how you get to that.
Right.
This is the process.
Right.
You don't just try to jump over everything to get to the one point you want to try to make, because they will shoot you in midair every fucking time. In the middle of that fucking hop. You take careful steps from one place to the next till you reach the destination required, and they have no opportunity to shoot at you.
That way when you're in your appeal,
I didn't ask a single thing they could object to. I didn't ask a single thing that could be construed as compound. I didn't ask a single thing that was misleading or caused anyone trouble in understanding what I wanted.
Or confrontational or anything.
I simply followed the breadcrumbs as they got dropped.
Mm-hmm.
And that is what thinking on your feet in court requires, because I listened to what I heard.
Yeah.
I didn't gloss over it. I didn't skip it. I didn't miss an opportunity. When something useful was dropped in front of me, I picked it up and used it. Does anyone disagree?
No.
I mean, that's the key. That's what a good lawyer does. But unfortunately, yeah. If you're doing pro se, you best understand all the friggin' technical aspects. That's the only thing I have
that's
seen.
what the lawyer would have to understand if he's
no
going to actually do his job.
It's the technical aspects, and you better go to court and watch a shit, pardon my terminology, but watch a bunch of cases before you set up there and try to do it for yourself, because it is, it's difficult for anybody that's done it.
And this goes back to what I keep telling everybody. This is a reason why there are lawyers and there are trial lawyers. The trial lawyers are the ones that can do everything that I just showed you on their feet day in and day out, because they're good that way.
Sure.
And then there are the ones that are good at generating the fucking paperwork and doing the legal research and finding the cases and writing up all the pleadings. They're the paper pushing lawyers.
Yeah.
Then the trial lawyer looks at everything they've got, sees whether or not he thinks he can do something with it, gets it corrected to suit the plan of action he's going to take, and goes that way, and then goes to trial and argues everything that he's got in that paperwork.
Yeah.
I understand, but you better get all the information, and if you don't, you better have requested all the information and have certification that you did request all the information.
Well,
do it properly, so that you don't give them that. They can't back out.
The short way to say that is be able to prove everything you claim to be true or false.
I agree. Yeah, and then let Chevron deference take over and just listen to the IRS, and they'll do it for you.
Chevron deference is dead.
I know it is, but but Letitia James still ain't in frickin' jail. None of them are in frickin' jail so far. But anyway, different thing.
They're not a state administrative agency or a government administrative agency.
The Administrative
They're a prosecutor's
Act
office
and all this stuff. It's the responsibility. The problem is that the courts, government. If we've gotten to the point where government is working on government's behalf and not for the people at every level, and federal, state, local, It's the government is working for the benefit of those employed by government or that benefit from government, and not for the people that are the citizens that are expected to pay for it. And that's my personal opinion after what study I've done. I'm not the one to stand up in court and argue it, but
Well, that's why being pro se is difficult. If you're going to fight it
There's
pro
no
se,
question.
you've got to learn to do it.
There's no question. You got to know not just the law, but you've got to know the technical aspects inside and out, and that's a problem.
You got to know the procedure. Absolutely right. Now, Julie, and you're talking about the diagram Helen referenced. If you'll remember, I showed you guys how to line up your. Remember what I told you about your trial book, where you've got your elements on one side and your questions relating to that element on the other, and how you take those questions and you use it to diagram any follow-ups or alternative routes you need to take based upon information you discover. Do you remember that?
Yeah.
That's what she's referring to.
Oh, okay. Thank you.
I was telling her I forgot which month. I don't know if it was last month or the end of March that we talked about that.
I don't remember which one it is either, but it was.
Neither do I, but I know it. I remember that little part really clear.
That just what y'all are referring to is not something that's on that Google Drive, is it? That chart?
If it's something that's simple and easy to use, it's on the Google Drive.
These attorneys are lying to people too. I mean, I just remember my attorney saying that he couldn't do anything because I hadn't been indicted yet, and that was like a year before I ever was, and I was trying to get him to do something. I was like, you have all the information, you need to take it to the DA. He goes, well, you haven't. I go, what's going on with my case? Well, you haven't been indicted yet. And I had all the information.
Well, he was doing what most attorneys do. He was waiting to see if he had to do any work. Unless there was an indictment, there was nothing he had to do.
But he'd been paid. That's the first attorney.
Well, that's exactly the point.
Yeah.
Okay? No work for all the money is better than any work for the money.
Yeah. But being that he'd been paid, you'd think he would have done something. And then,
Well, what would he have done if he had done a bunch of something and then they didn't indict you?
I'm gonna have to close up. Thank you very much. I appreciate it. Very informative. I'm gonna have to cut loose. So I just wanted to say thanks.
Yes, sir. No problem. Thanks for coming.
Okay, this is what I'm saying. I'd already talked to the court investigator about everything because my attorney had me meet up with him. He's the one who provided the picture of Alex to me after that meeting we had. Like, I wasn't even home 5 minutes from the meeting.
This is Jacob, right?
No, I'm talking about Isaac from the beginning. I'm just because I have questions about
the lawyer you're saying showed you the picture.
No, this was the court investigator that my attorney Rudy Vasquez had me speak to. Okay. He had me speak to the court investigator. His name was Mario Esquivel. Okay. And anyway, so I went to go speak with him. I told him everything that happened, and he said, "Okay, I'm going to get together with your attorney, and we're going to bring all this information to the DA." That was like a month after my original charge, my first got framed. However, months and months and months go by, and I'd call my attorney every other month and say, "Hey, what's going on?" Because I hadn't heard anything. He'd always tell me, "Well, you haven't been indicted yet." I go, "Well, why would I even be indicted if you have all this information?" And he's the one whose secretary took my text messages off the phone. So he knew very well, and I told him about like Cena and all those other people being framed. So he had all this wealth of information. And went ahead and let me get indicted. Well, when I called him, I said, when he told me I hadn't been indicted yet, he says, "Let me make a phone call and I'll get back with you and I'll call you back." He didn't even bother to call me back. He sent me an email the following day, and I had been indicted that day when I called him. That's just kind of,
But then that would be a lack of service, right?
Well, yeah, but to top that off, he arranged a meeting 2 months after that for October, and I'm thinking it's just a game plan, right? No, it's a meeting because he wants to be withdrawn from my case, so he had me sign papers. Well, I wanted to voluntarily, too, because I didn't want him being my attorney. Who wants someone that's not going to defend you, on your case? So I signed, he wanted me to withdraw from my case, and I did. And but I'm just saying about the whole indictment thing. He kept telling me, "You haven't been indicted yet." Well, when this person had proof I was innocent, why did I have to be indicted? Why couldn't he taking that information to the DA like they said they were going to do? I don't understand that.
Well, that's the problem with the attorneys. That's the reason why, if you don't know what they're required to do and how they're required to do it, then you can't control them.
Well, that's true. Like a lot of people don't know what a retainer is. It's just a gift.
Yeah. The laws, the Chapter 82 of the Government Code says it's a gift.
Yeah.
Okay, now real quick, anybody know who Austin is? Austin, you want to introduce yourself to the class?
Hi, Austin.
Hi, yeah, this is my first time joining the call. Yeah, I recently got a speeding ticket, and I looked into some of the laws. I'd seen Eddie's class on InfoWars about it, and I looked into some of the laws that I was charged with the prima facie speed limits, and just trying to figure out what I'm going to do once I finally got to go meet the prosecutor.
What state is this?
Texas.
Okay. Well, I have a motion for it, or at least I have the body of a motion for it.
Okay.
Hang on just a second.
Did he catch you with a radar gun, or just say you were speeding, or?
Yeah, it says radar.
Oh, well, he has an easy way of handling that too, right, Eddie?
Yeah, radar's irrelevant.
Well, yeah, but the questions.
No,
Austin,
the question's got nothing to do with the radar gun.
Yeah, I mean that was gonna be one of my questions. Is like, if this is my first time doing this, first time fighting the ticket. Already pleaded not guilty, requested trial by jury, and I mean honestly don't really have a clue what I'm doing in court. So I guess my question was like, where should I start? Where do I start to try to get prepared for this?
Well,
other than reading the statutes, which I have looked at the statutes and I've seen, what it said, which the prima facie is not very clear at all.
What do you mean it's not very clear?
Well, it's not very clear to me how I have violated that, in the sense that when I read it, it says that, you can't go at an unreasonable speed, and then it has a couple different ways that you could be unreasonable. And
okay, look at the chat, everybody. There's a document I just put in there. Austin, you're going to want to download that, and you're going to want to read it.
Okay. Thank you.
Now, that's the body of a motion. It's not a full motion. It doesn't have the style at the top. It doesn't have the proof of service and the proposed order and the signature blocks and everything at the end. This is just how the body of the pleading should read.
So this is a motion to dismiss.
Yes. Once you read it, you'll understand why.
Okay. Well, I will definitely take a look at this.
Now, the key to that motion to dismiss is this. Even if they don't dismiss it, it tells you every single thing you need to know to show they can't prove their case.
Okay.
Everything you heard me do in this class, you can use that motion to prepare your questioning for cross-examination from. You know what a leading question is, right?
Yeah.
Okay.
Generally.
A leading question is one that can only get one of two answers, yes or no, true or false.
Got it.
Okay? On cross-examination, especially as a pro se, the only kind of question you want to ask is a leading question. You literally want to put words in the witness's mouth and make them eat them. Got it?
Got it.
Okay. So you use this to write your motion to dismiss, and you file it, and you serve both the court and the opposing counsel with it. And then you also use it to formulate the questions you're going to ask for cross-examination, because it tells you every element they have to prove in order to charge speeding in the first place. The complaint will not have 90% of it. Most of the stuff you read in this motion will not be mentioned anywhere in the complaint. That makes it a faulty complaint. Okay? So it's what in law is called a defective charging instrument, even though a complaint has never been a charging instrument except in the court's wishful thinking. But in either case, everything they have to allege and prove is every element of the allegation. And the law is very clear upon how many elements that actually is, because it takes multiple statutes to make it. And even then, the statutes themselves don't actually create an offense, all of which you will find in the motion that you're going to read. Understood?
Yes. Now, in terms of timing of introducing this motion, is this something that I would do before the meeting the prosecutor gets scheduled? Or
it
during that
matter.
meeting with the prosecutor?
You cannot be made to meet with the prosecutor. Okay? Having you meet with the prosecutor is a due process violation. You're not represented by counsel, and even if you're acting pro se, putting you in a room to let's make a deal with the prosecutor so they can use anything you say against you is a violation of your due process rights.
Interesting.
Okay? So, when they send you in there to the prosecutor, that's all you need to ask them. Are you the prosecuting attorney on this case, or are you part of the team prosecuting me on this case? Yes. Then I don't have any desire to speak to you whatsoever prior to trial, unless the discussion involves you dismissing the charges and going on your merry way. Does this discussion involve that? No. Well, then we don't have anything to talk about, and that's the end of it. Anything else is playing let's make a deal. That's it.
And when it comes to let's make a deal, like what is it?
They're going to get you to admit guilt to something, the same thing or something lesser. So they'll either lower the fine or whatever. It doesn't matter. In any instance where you play let's make a deal and take the deal, you fucking lose. Period.
Got it. Well, just from listening to this class, I'm starting to wonder, well, what did I get myself into here? Do I really have the strength?
Well, that's why taking the class is a good idea rather than just going in there on your own thinking you know everything, or that you know that all you got to do is this, and this, and you'll be okay. That's the furthest thing from the truth there is.
Yeah.
Here's the thing about court and Tapper's idea of the truth will out. The truth will only out when you force it into the open. If no one forces it, it's never seen. And what happens is based upon everybody's perception of reality instead of the actual reality. You understand? Things like what's are in that motion, that's how you force the truth into reality and make it visible and force them to talk about it.
I see.
And trust me when I tell you, what's in that motion is not something they want to talk about. Millions upon millions of dollars a year in state-generated revenue depends upon them completely getting away with what we're arguing they're doing in that motion. And the more people they have in court fighting it based on what's in that motion, the more likely that little secret is to get exposed. Therefore, the more people they tend to cut loose so they don't have to face that argument in court.
What do you think the likelihood is they would dismiss without it going to trial? I can't give you a
likelihood because it all depends upon the prosecutor, the judge, and what they think of you.
I see.
It doesn't matter what paperwork you file if their impression of you is, 1, you didn't write it, 2, you don't understand it, 3, you don't know how to use it, and 4, you don't know the rules to allow you to use any of it the way it needs to be done. That's what they're counting on. And 99.9% of the time, they will be 100% correct in that assessment. Wouldn't they?
I mean, in my present state, for sure, yeah. I mean,
okay. Well, there you go.
A lot of reading to do, a lot of research.
A lot of everything to do. But then again, that's why law school exists and why it takes so long to become one.
Yeah.
Okay, so the point here is, if you're going to learn this as a pro se, then you need some place to do it that's not teaching you stupid bullshit that won't get you anywhere. And that's what this class tries to do. I can't say I've helped everyone because not everyone has the aptitude for this or the desire to do it right. They just think they can wing it after a couple of things and be done with it, and they'll succeed, and they're wrong. Unless they're just dumbass lucky. As the old saying goes, better to be lucky than right. Okay, but for those that can't be lucky or aren't lucky, then being right's the only option you got left. And the only way to be right is to beat them black and blue with their own rules because you know them better than they do. And that's what I've dedicated myself to doing, knowing the rules and how to use them better than they do.
Well, so in that regard, what would you say is the essential reading in terms of the Code of Criminal Procedure and whatever else to,
Well, for speeding tickets and a pro se, the first place is 45A. After that, you've got to go to Chapter 1, Chapter 2, Chapter 16, Chapter 15, Chapter 14, Chapter 20, Chapter 21. There's a whole plethora of stuff you've got to know. Because the procedure isn't just, how do I go to court, argue my point, and leave without having to pay. That's not the procedure. There's all kinds of shit in between. There are timelines. There are things you've got to comply with by certain times and dates and et cetera, based upon what's happening in the case. And you get all of that from the rules of procedure.
And objections.
Okay, so like I say, that's why Julie was asking if you're enrolled in the class. If you want to know how to go to court and fight this is the best place to come and practice and learn. Because we do things not only like what we do tonight, but we'll sometimes conduct mock trials and so on and so forth to teach you how the courtroom is going to treat you and how you're going to have to react to it and what you're going to have to do with the information while you're in it. Tonight was just a very one-sided example of that. Tonight was just me asking you to figure out how to conduct a cross-examination based upon a surprise iteration by a witness. That's just one aspect of going to court. There's all other aspects associated with what happens with the answers you get from a witness based upon what you intended to ask them, not what came out as a surprise. So Julie gave you the links you could go to if you want to go and sign up for the class. You can see how much it is there. For what you're getting out of it, it's extremely cost effective, believe me. And I haven't raised the prices since I started doing this in, what year did I start doing this? 2009?
You started back in 2021, and I've been there ever since.
No, that's when I started this online class. I started these classes at Brave New Books in 2009.
Oh, yeah.
I started
this online you've done since 2021 in June, and I've been here since then.
So the point being that, you can go it alone if you want to, and I'll wish you the best, but it's a waste of good paperwork if you do that. See, the problem with giving you the information that's in the body of that motion is great. You know everything they're supposed to prove and how they're supposed to prove it. Problem is you have no idea to make them hold it and do it properly and in compliance with the rules because you don't know what the rules are.
Right.
So I guess you could say it's a loaded gun, but it's only got one bullet.
Yeah.
If you want to get in a gunfight, you better stock up on the rest of those chambers. And that's what the class is for.
All this known to humanity. Kristen, what is amazing?
What was that, Robert?
Eddie?
Yes?
Going to what you said, I've been listening to you for years, and I just got through with a court case that they dismissed in the interest of justice after I beat the crap out of them, like I've done so many other times. That's about the fourth time I've done that.
And how did you learn to do that?
Well, hanging out with jackasses. Hanging out with guys like you. That's how I learned to do it.
Yeah, and that's the whole reason for what I do is to try to teach people how to do it.
And you 100% you beat them with their own rules. I not only beat them this time, I've got an internal investigation going on down at the sheriff's department. The 3 officers involved are probably looking at losing their jobs. And it was from things that I learned from you and the crew, right?
Mm-hmm.
But I'll tell you what, I had a trial by jury, and it was way over my head. I learned a lot in it. I thought I knew a lot, but until you're in the mix, you don't realize you don't know as much as you think you do.
Yeah, it's like hand-to-hand combat. You think you're a good fighter till you get in there with somebody who actually knows how to fight.
Right.
And that's the problem. When you go at this pro se in these courts, you are the underdog nobody knows going up against, for lack of a better way of putting it, Mike Tyson in your first fight. That is no place you want to be as a rookie.
No, and you're 100% right. Even this time around, I felt like a rookie half the time. they ruled every motion I put in. There was no opposition to one of the motions, but the judge denied every one of them.
Their motions or yours?
My motions were rock solid, and there was no opposition from the district attorney, and the judge ran right over the top of me. I challenged the jurisdiction, ran right over the top of me. They threw in a ringer judge. He tried to run over the top of me. But when I caught the DA with her hand in the cookie jar because she didn't find her own rules, that judge had no choice but to dismiss in the interest of justice, because he held her little behind in his hands, and he didn't want to. He knew that I had to set up my case for a appeal. I mean, I had a lot of appealable events that happened, and that is so important, because the chances of me winning in that court without an appeal was slim to none at all. Because Eddie, I would go, wait a minute, I just made, denied. Oh, and I deny them all, he said. I mean, that's the kind of shit you're up in, they just keep going.
Yep. And the thing is you can't let that kind of shit fluster you. You've got to take it in stride and know how to deal with it.
Yeah. Anyway, I just wanted to put my 2 cents. I just got on and thought I'd put my 2 cents in on how valuable what you have to offer has been to me. And I can't thank you enough. Anyway.
Well, I appreciate it. Thank you. In any case, Austin, that's the reason why I say if you go this alone, all right, more power to you. But if you want to learn how to do it right, this is where you go. That or law school.
Yeah. All right.
Okay. All right, guys. That's it for tonight. Thank y'all all for being here. I appreciate you.